Assalamu alaikum. Welcome to Just Law. This is the second segment, and my name is Bilal Hussain Khan, and I'm your host on Just Law. Now, at the bottom of the screen, there will be a telephone number, and it's important to note that this is a live show. You can call in and you can ask any questions. Now, just before the break, we had a question come in regarding electronic monitored curfew. Now, for our viewers who are not aware of what that is, in certain cases, normally where there's a risk that the suspect will abscond, meaning that he will run away, he won't stay, she will not stay wherever they're meant to be, then the court will impose a condition that you reside within your property between certain times of the day. Now, it can be any time. It could be during the night, during the day, depending on your circumstances. However, generally speaking, what we find is the courts normally impose curfews between the hours of 7 p.m. to 7 a.m. to ensure that suspects are inside the property. Now, there's different types of curfews that can be imposed on a person. Now, firstly, it could be a simple live and sleep each night at a particular address. So the condition, I understand there's a call waiting. Assalamu alaikum, caller.
Sorry, talking.
Assalamu alaikum.
Walaikum salam.
You're speaking to Bilal. How can I help you?
Sorry, disappeared. I just wanted to ask a question regarding. It's a bit complicated. So I've just recently got married, and my husband was arrested for possession with intent to supply Class B drugs.
Okay.
But when he did it before he got married, so he was trying to stop it just before getting married, and that's what they've got him on. But he wasn't actually doing that. They found some plants in the attic, and they were growing them. They weren't gone through, so he had stopped it, and there's evidence that obviously he stopped it. And I was just kind of really worried about the consequences if he's growing them. It's worse than what he's been charged with, or what we can do from here.
So he's been arrested, I'm presuming. Has he attended court?
No, it's just been a police station interview.
Just at the police station interview. So ordinarily what happens is at the police station, they would have taken his first account or done a first interview, depending on whether he's given an account or got no comment. The police will then have a period of time to investigate to see whether or not they find any further evidence, such as my understanding is cultivation of cannabis, because there were plants upstairs. They'll have a look to see whether or not there's any evidence such as forensics, DNAs, etc., of any other people with the plants, etc. They will most probably have seized his mobile phones. And then what they'll do with the mobile phones is they'll have a look at the call data and have a look at the text messages to see whether or not there's text messages which show that he's dealing in drugs, because the offence for which they've released him from custody with is possession with intent to supply, which basically means that he had the cannabis in his possession and his intention was to supply it to another. Now, the police have to prove that case. It's not for your husband to prove that he's not doing it, but by virtue of the fact that there were plants and those plants are illegal to possess, then there's certain inferences that are drawn. However, they're only inferences at this stage. Now, what your husband is going to have to do, especially if he's got previous convictions, if the prosecution wish to use that, then potentially they're going to say he's got a propensity to commit such offences. He's done it in the past, so we believe he's doing it now, but that's not good enough. So depending on your husband's personal circumstances, it may be the case, for argument's sake, so he was growing it for himself. It could be the case that he was social supply. It could be a case that he was going to supply it to anyone and everyone who wanted it. So depending on his personal circumstances, there are what's called sentencing guidelines, and what you'd be able to do is have a look at his personal circumstances, have a look at where his falls in on the sentencing guidelines. So depending on the value of the drugs, the weight of the drugs, depending on whether they're saying it was a commercial setup, whether it was a social setup, or what it was, then you'll be able to judge as to what the potential sentence may be if he's ever charged with it and if he's ever convicted of it. Now those particular details, if he's got a lawyer already, I'd ask you to contact that lawyer, have a meeting with them, sit down and ask them what the position is. And if you don't have a lawyer, it's important that you do consult with a lawyer. And if you want to contact the control room and take my details, if you don't have your own lawyer, then what I'll do is within the next couple of days I'll contact you back, speak to your husband, and then have a look at the circumstances and then advise you accordingly what I think of the case. I hope that's answered your question. Is there any other concerns you have?
Yeah, it was just that in his interview he did give a little account and he said it was for personal use.
Right.
But I was just wondering, like, the amount of plants that were growing, if you can say it was for personal use.
Look, it depends. Every person's different. Some people smoke, don't smoke, and some people smoke loads. It depends on the how many plants there was, how mature the plants were, how much would have come, what he was intending to do with them. Once the plants matured, once they had the drugs on them, what he was intending to do with them. And it's for the police to prove that. It's not for your husband to prove otherwise, like I say. But what the police will rely upon is if there were significant amounts of plants, then they'll say that we believe that this was a commercial setup, it wasn't a personal setup. We believe that although he's saying it's for personal use, there's no chance this was personal use. And then it'll be a case between the defence and the prosecution to come to a middle ground, or alternatively to fight it either way. But it all depends on how much plants there were. And we've got to be sensible, and it's always important to be sensible with your personal circumstances and be true to yourself. Like, for argument's sake, if there's 20 plants there, then it's not going to be personal use. If there's 1 or 2 plants, then potentially. If there's more than 1 or 2, but a few of them are not growing properly, or whatever his personal circumstances. So we really have to judge all the circumstances before advising accordingly in those circumstances.
No, that's perfect. Yeah, I'll get your number from the control room.
That's
Hopefully
fine.
I can give you all the circumstances. Thank you for your help.
Thank you. Assalamu alaikum. Now, I'll move back to the discussion regarding the electronic monitored curfew. I was explaining that there's different ways that a court can impose conditions upon you. The first is for you to live and sleep each night at a particular address. So they'll say the condition is to live and sleep each night at this address. The second is with a doorstep condition. Now, you have to live and sleep at a particular address with a doorstep condition, which means that between 7 to 7, for argument's sake, if that's the condition that you have, an officer will knock on the door, and it's part of your bail to present yourself to the officer to say, yep, I'm inside the property. Now, the next one up to that is an electronic monitored curfew. So what you'll see is a device, which is like a watch, will be fixed onto a person's leg, and then what they'll do is fit another device inside the property, and that device, as soon that there'll be a range to that device which will be set by the company who comes to install the tagging equipment, and then if you ever exit your property, and then that'll show and it'll go off, make a noise, and that'll go back to the company to say that this person has left his house or breached his conditions by a certain time. Now, there are obviously defences to that, and it's for the suspect to prove that he she had reasonable grounds to breach those conditions at that time. So it's not hard set in stone that you have to remain inside. So if you have a genuine emergency that's been established, such as, I don't know, you've had a heart attack and then you've been taken by ambulance, that's a scenario where you're probably not going to get summons to court, you're not going to get arrested for breach of bail. The other one is if you're the sole dependent of a child and you're on a curfew, something happens to the child, you have to go, then that'll be deemed as a reasonable excuse. So there's loads of scenarios, and it's for the defendant to show in court on the balance of probabilities that there was a reasonable excuse, or for argument's sake that the breach didn't occur. We often find ourselves before the court where the information is that our client has breached the tag. However, client says, I've not breached it, and the point is argued before the magistrates and is left to the magistrates to decide whether or not they believe the paperwork, they believe the evidence tendered by the prosecution, or they believe the evidence tendered by the defence. And then depending on that, they'll make a decision as to whether or not you will be released again on bail with the same conditions, or whether your bail will be removed and you'll be remanded into custody, or your bail will be extended and conditions will be changed. So those are the different scenarios insofar as electronic monitored curfew is concerned. And it's always important, like I said to the caller, if there is a genuine emergency that's established, then at that stage you do everything in your power to contact the relevant parties. So you'll contact the tagging company. It's normally a touch device or there's a phone attached to it, and then you can contact the people, notify them of the problem. You can ring 101 24 hours a day, notify them of the problem. You can contact your solicitor, notify them of the issue, and then at least you've done everything in your power to notify all the parties present. And then if you are ever arrested for breach of bail, then those issues can be addressed. Inquiries can be conducted with the police as to whether or not you called, with the tagging company, with your solicitor, and all that could fall part of your defence in defending the breach on the basis of it was a reasonable excuse. And then if you are successful in arguing that, more likely than not, the court and the prosecution will agree to release you on bail with the same conditions as before. Now, the next question that was asked of me just before was in relation to Class B controlled drugs, and the caller stated the charge was possession with intent to supply, but I'd be quite surprised if it's not cultivation as well. So cultivation of cannabis, bearing in mind the plants were found in the room, and this is becoming a more increasing problem throughout England and Wales, where people are deciding to cultivate their own cannabis, and quite often there's a lot of other offences attached with it, such as extracting electricity used to grow the cannabis, etc. And each case, once again, is taken at its own merits. So you'd look at the facts of the case, you'll have a look at the quantities involved, and then you'll have a look at what the position is. My understanding is there's another call waiting. We'll go to the call. Assalamu alaikum.
Walaikum assalam.
You're speaking to Bilal. How can I help?
Sorry, I have one question. Can I speak in Urdu or can you understand Urdu?
Yeah, I can attempt to speak Urdu. Ji.
जी प्लीज असल में मेरे कज़न ब्रदर का केस है तो उसका प्रॉब्लम ये था कि उसको कैंपस में जब क्लास बी में क्लोइंग में सेंटेंस हुई थी 2009 में उसने क्राइम किया और ही वाज इलीगल दैट टाइम टोटली ही गॉट नो वीजा नथिंग सो उसके बाद उसकी बेल हुई मेरे कज़न पूरे दूसरे उसके भाई ने बेल करवाई और पे आउट हुआ 7.5 months इनसाइड था बाकी प्रोबेशन पे था तो उस वक्त उसका डिपोर्टेशन ऑर्डर इशू हुआ लेकिन उसे उस वक्त डिपोर्ट नहीं किया गया फिर केस चलता रहा जैसे एक खत्म हुआ दूसरा डाल दिया ऐसे कोई एप्लीकेशन सारे सिस्टर डालते रहे तो फिर उसकी इधर ब्रिटिश गर्ल से शादी हो गई बच्चे हो गए तो پھر کورٹس ہوئی کافی، ہر طرح کا کیس کیا گیا، ڈی این اے بھی بچے کا دیا گیا، پھر اینڈ پہ اسے ابھی 2014 دسمبر میں سے ڈپورٹ کیا گیا. ابھی سے ڈپورٹ ہوئے تقریباً 6 ایئرس ہو رہے ہیں. تو میں یہ پوچھنا چاہ رہی ہوں کہ اس کے یہاں آنے کا کوئی چانس، برٹش اس کی وائف صاحب بچے بھی 3 بچے ہیں اس کے، تو اس دوران 2009 سے لے کے 2014 تک ادھر ہی رہا، ڈپورٹ نہیں کیا گیا. یہ
جی
کرائم 2009 مارچ میں ہوا.
جی
تو ابھی اس کے کوئی واپس آنے کے چانس ہیں؟ جس سلسٹر سے بات کرتے ہیں وہ پیسے لے لیتے ہیں اور کام نہیں کرتے،
جی
تو بہت پریشان ہے. کوئی اس میں ہیلپ ہو سکتی ہے کہ یا اس کے اوپر 10 سال کے بین لگ کے وہ نہیں آ سکتا؟
جی. تو یہ ایشو جو ہے نا امیگریشن ہے، تو یوزلی دیکھیں کیونکہ کافی عرصہ بھی ہو گیا نا، 6 سال ہو گئے کہ یہ بھائی صاحب جو ہے نا ڈپورٹ ہو گئے ہیں. تو 6 سال میں کورٹ یہ دیکھے گی کہ یہ بچے وغیرہ کی کوئی کانٹیکٹ ایشوز ہے یا نہیں، کیونکہ وہ ادھر رہ رہے ہیں اور 6 سال کے لیے کوئی کانٹیکٹ اپنے والد کے ساتھ انہوں نے نہیں کیا، تو وہ اٹیچمنٹ وغیرہ جو ہے نا وہ نہیں
نہیں وہ
ادھر.
تو
جی
میم 3 ٹائم وہ جا چکی ہے، فیملی بچے اس وقت پاکستان گئے ہیں
جی
اور وہ ہر وقت کانٹیکٹ میں ہوتا ہے. وہ سب امیگریشن سلیسیٹر کو دیا ہے، ریووکیشن آرڈر اس نے ڈالا تو
جی
وہ ریووک نہیں ہوا. اب
جی
پھر اس نے اپیل کی ہوئی ہے، تو اس میں وہ ڈیلے کر رہا ہے کورٹ کے لیے. وہ کچھ ہمیں ہوپ نہیں ہو رہی، جیسے وہ بہت پیسے بہت ہو رہا.
جی
پلیز میری آپ سے یہ ریکویسٹ ہے کہ ایسے جیسے 6 سال ہم ہو رہے ہیں پیسے دیتے دیتے، وہ کہتا ہے اب ہوگا اب ہوگا، 6 منتھ سے لے کے نا 6 سال ہو گئے ہیں. تو کیا مجھے یہ کنفرم ہو جائے کہ واقعی 10 سال کا بین ہے، 10 سال کے بعد ہی وہ ریووک ہوگا، تو میں اور پیسے نہ لگائیں. تو پلیز اس میں کچھ صحیح ہمیں ایڈوائز کر سکتے ہیں. بہت زیادہ پریشانی ہے،
جی
فرسٹریشن ہے ٹو بی آنسٹ.
جی. آپ ایسے کریں نا کہ یہ کانٹیکٹ سینٹر سے جو ہے نا میرے دفتر کا نمبر لے لیں، تو
اوکے
امیگریشن کا وکیل جو ہے نا ہمارا آپ کو فون کر کے تو بتا دے گا کہ ایویڈنس کیا ہے. آن فیس ویلیو جو میں دیکھ رہا ہوں نا ایویڈنس، تو اگر ڈپورٹیشن ہو گیا تو یہ کافی مشکل ہوگا کہ اس کے اندر جو ہے نا وہ کینسل کر دیں یا اپیل. یہ اپیل وغیرہ جو ہے نا جب وہ ادھر تھا تو اس وقت ہونی چاہیے تھی، تو ابھی جو
سب کیا،
جی
ایوری تھنگ کیا.
جی
اس میں جوڈیشل ریویو 2 دفعہ کیا، ہائی
جی
کورٹ میں گئے، سب کچھ کیا، سب ریفیوز ہو گیا.
جی
انہوں نے کہا بس اس کا ڈپورٹیشن آتا ہے، تو یہ ایلیگل تھا. جب کرائم کیا یہ آپ واپس جائے تب ویزا لے کر آئے.
جی. تو آپ ایسے کریں نا، کیونکہ یہ تھوڑا کمپلیکس کیس دکھائی دے رہا ہے نا، تو آپ امیگریشن وکیل سے جو ہے نا رابطہ کریں. تو اگر آپ ڈیٹیل دے دینا تو میرا امیگریشن وکیل آپ کو فون کر کے تو بتا دے گا سب انفارمیشن. ٹھیک ہے نا؟ I understand the call has gone. Now, we're just dealing with that issue of deportation. Now, it's quite important for our viewers to know that if you do not have a British passport and if you commit any criminal offence and you are sentenced to a term of imprisonment exceeding 12 years, then the Home Office will make an application. They'll revoke your entitlement to stay here and then serve a deportation notice upon you. And if you are in a position where you are served a deportation notice, then it's important for you to challenge that immediately prior to the deportation. Now, there's a number of reasons why you can challenge any deportation notice, and the most common is on the grounds of human rights, on the basis that you have family here, especially like the last caller, she said they had children here, DNA testing was done, etc., to confirm that. Therefore, all of this preparation needs to be conducted at the time the deportation notice is served upon you, and then each case is looked at on its own merits, and circumstances are looked at depending on how severe the crime is, and how serious it is, and the public interest involving around that. Generally speaking, the courts will be quite hesitant in deporting someone who has family ties here, such as children, wife, etc. And you can argue under human rights ground that there's going to be a significant effect on the right to a family life within the United Kingdom. But you'll have to prepare all of these documents and serve these prior to the expiry of that deportation notice and prior to the deportation. Now there may well be avenues in challenging that, appealing against that thereafter. However, from the top of my head, I'm not aware of such arguments. However, if this is a topic that our viewers would like me to discuss, then we can have a segment dealing just with deportation. I will speak to my immigration colleague and get them to speak about this because it's quite important for everyone to understand. And this is the importance of a lot of people come before us and they have indefinite leave to remain in the United Kingdom, and they've had it for a significant period of time, but they've never gone ahead to obtain a British passport, and that always causes a problem thereafter because your nationality is not a God-given right. It's given to you if you fulfill the requirements, and one of the requirements is for you not to have committed a criminal offence within the United Kingdom, and for you to be a upstanding member of the community. And any cases such as our first caller stated that you had a failing to report, that will also have an effect on the application. Those will have to be disclosed, and then your caseworker will make a decision as to whether or not you're a suitable person to be given a nationality in due course. Even though you meet all the other requirements, this requirement will fail, and it may be the case that they ask you to extend your current visa, and under the Rehabilitation of Offenders Act, whenever that previous offence has been taken off your criminal record check, then at that stage you may be entitled to apply for a British nationality. And it's important for everyone to know that now we're nearing the end of the show. I hope I have given an insight into the police caution, the fact that it's your right to remain silent, the fact that it's the police to prove any case against you. It's not for you to prove your innocence. There's nothing wrong in seeking the advice of a solicitor, and thankfully in the United Kingdom, England and Wales, legal aid covers police station advice. Even if you're a millionaire, billionaire, etc., you'll get a duty solicitor for free of charge. Now, next week we'll continue this show. We'll continue with rights and entitlements in police custody, and then we'll talk about further issues. I'll end the show here. I'll see you next week. Thank you.